All right, thank you guys for joining us. You are joining us for our third program here in the Loeb and Loeb Connectivity webinar series. This one is called Dark Patterns, Increased Use in E-Commerce, Increased Focus by Regulators and Litigators. David and I will discuss legal trends, practical challenges, and litigation and enforcement risks associated with the recent growth in technology-enabled advertising, marketing, and sales. Before we begin, I'd like to remind everyone that we are using a Zoom webinar platform. Unlike a Zoom meeting, you will not be able to unmute your phone or turn on your video. So while you will see us and the presentation, we won't be able to see or hear you. However, the Q&A function will be available to you, so please submit any inquiries via the button at the bottom of your screen. We'll be closely monitoring questions and answers throughout the presentation, and we will try to get in as many of those questions as we can before our presentation ends. Our session today will last approximately 1 hour, and we will be sure to pause midway through to provide you with the CLE code. The attendance and evaluation forms were included in our reminder email sent earlier today, so please make sure to check that email for those forms as well. All right, now that we've covered the logistics, let me turn you over to David Mallen, who will introduce dark patterns.
Thanks so much, Jason. So thanks everyone for joining us, and it's a pleasure to work with Jason and talk about this important topic with you. So we're going to talk about dark patterns, and let me just talk about some of the things that we're going to cover. And of course, as Jason mentioned, we'll be doing giving the CLE code sometime in the middle of our presentation. But the topic of dark patterns is one that has been gaining a lot of momentum lately, and it's been making the news, and it's certainly been on the radar of enforcers and attorneys and any company or brand that's involved in e-commerce, advertising, privacy. We're going to cover why this is such an important topic. What are dark patterns? Why is it hot right now? Some of you may be aware of a workshop that was held by the Federal Trade Commission back in April, considering the topic of dark patterns as a consumer protection concern, considering the possibility of rulemaking, additional enforcement. We're going to talk about how dark patterns affect advertisers, how they affect brands. As mentioned, it covers a lot of different behaviors, a lot of different activities in e-commerce. Jason and I will also be covering some of the enforcement risks and some of the activities. We'll look at some practical examples of the kinds of behaviors that we're talking about, and hopefully come away with some practical guidance, some thoughts or ways of looking at dark patterns so that we're able to work with our clients and use the internet and use e-commerce in a successful way without inviting more risk than is necessary. So what are we talking about when we're talking about dark patterns? It sounds like such a nefarious concept, dark patterns. It sounds like the latest installment from the Marvel universe, some kind of supervillain. And a lot of our clients think, well, you know, that's not us. That's something that relates to some real wrongdoers. That's not the stuff that we do. And as we'll talk about, dark patterns covers a lot of behaviors, or potentially could. The definition of dark patterns, and there's a few, but the one that's used most commonly is a deceptive part of a digital user interface, some part of an interface that is designed to trick the user into making a decision that they would not have otherwise made. And one of the controversies about dark patterns really is that definition. I mean, taken very broadly, that could refer to all kinds of advertising, any attempt to influence consumer behavior. Now, clearly, it can't be the case that any aggressive sell message is a consumer protection concern, but we need to discuss and cover where those lines are drawn and how the Federal Trade Commission and other enforcers are looking at that issue. So some of the kinds of categories and behaviors that constitute dark patterns, we'll cover some of these and we'll show examples of some of these. Visual misdirection, getting consumers to not focus on perhaps some important material disclosures. Trick questions that are intended to guide consumers down a path that may be to prevent them from canceling a subscription, or to maybe not see that they've just signed up for some pretty extensive shipping and handling fees. It could include things like pre-checked boxes on a privacy policy, the attempt to create undue urgency to push a consumer in a particular direction. Some of these behaviors and some of these practices already fall under the umbrella of consumer protection law. And we'll sort of talk about the way that that's covered and what's different about dark patterns and the way that regulators, and particularly the Federal Trade Commission, is thinking about dark patterns as a kind of unique and heightened consumer protection concern. So if we can go on and just to take a look at some of the examples and the way that dark patterns are being considered by the press and by a lot of advocacy groups. Very recently, a third-party group did a survey and examined thousands of retail websites. And according to them, they found over 2,000 examples of dark patterns, all of which, in their view, could potentially raise consumer protection concerns. And a lot of routine practices in e-commerce potentially could trespass on that line or perhaps go over the line into what certain regulators might consider to be dark patterns. Some of these have to do with disclosures, as we'll get into it. But generally what we're talking about, again, are the kinds of practices that constitute deception, that would constitute a deceptive or unfair practice under Section 5 of the FTC Act. And of course, that trickles down to various consumer protection laws by the states and touches upon class action lawyers, again, as Jason will get into. So in thinking about the attention, though, given to dark patterns, we know that the trade organizations, there's just a lot of buzz about this now. And if we can go on to the next slide, part of it, of course, comes from the Federal Trade Commission, but there's just been a lot of exposure in terms of sneaky charges and tricks, and particularly when we're talking about very small screens and mobile devices and phones. So one of the examples or one of the behaviors is what we'll call sneaking. This is an example right here, dark patterns tip line, where you're checking out and suddenly an extra tip or service charge is sprung upon you. This is actually a double entendre. This is a play on words. This is an organization that wants people to report instances of dark patterns to them. And as you know, consumer class actions are watching this space very closely. So this is an example of sneaking, and that, of course, is going to be an attempt to misrepresent a user's action or delay information. If we can go to the next slide, just an example of that would be in a buy flow. You're selling something online, the consumer wants to buy something, and suddenly something sneaks into the basket. Maybe they see it 3 screens in, maybe there's a defense that it's there before they actually check out and pay, but it would, in the view of the FTC, be considered sneaky, deceptive. It's not prominent. It should have been more, it should have either been disclosed earlier or in a more prominent way. We're going to talk also about urgency, this idea of trying to direct consumers in a certain way through the buy flow by creating, in some cases, a false sense of urgency, imposing a deadline about a sale that they're going to miss out on. They're going to miss a great opportunity. They're going to put their family at risk if they don't buy a certain level of insurance, or they're going to put their data at risk if they don't buy a certain program for credit protection or for consumer protection. These are the kind of practices which some of you will recognize as already covered under consumer protection law. But again, this is an area where there's renewed focus on the part of regulators like the FTC. So let's take a look also at this issue of misdirection, where we use visuals online or in an interface to steer consumers towards a choice. Confirm shaming is I guess the way that they're calling it now. And you'll see this, and you've probably encountered it yourself, where you're strongly, we have the red button that yes, I'd like the discount, or no, I want to pay the full price, trying to perhaps appeal to a sense of shame, to make you feel stupid for making a particular choice. These are subtle activities, and some of them are really right on the line of aggressive advertising and what somebody like an enforcer or someone from the FTC or a class action might allege is unfair or deceptive practices. Just to cover a couple of the other examples of dark patterns, social proof, influencing users' behavior by describing experiences, how many are sold, if it's not accurate, of course, where scarcity is an example of that. And we can go to the next slide. Buy now because we are running out. You will be without, this very important product. Again, false sense of urgency, pushing a consumer to make a choice they would not have otherwise made. One area where it's really getting a lot of attention on the part of regulators and driving some lawsuit is this idea of obstruction, trapping you into a subscription or a website, making it difficult to cancel. You want to leave and they want to give you another offer or 3 more offers, or you have to go through a rather complex navigation of a website in order to cancel. Those are the kinds of behaviors that they covered at this FTC workshop. And we'll talk about it a little bit more in terms of where the FTC is. But one of the important takeaways of that workshop is there was a lot of academic research offered on the part of what is working, what is getting consumers to go down this path of deception where they're unable to cancel or forced to buy an item that they never had intended to buy. And the Federal Trade Commission watches and reads and is on top of this consumer research. So forced action would be an example of that. You're either urged or forced to enroll in something that you might not have wanted to enroll in. These are the kinds of things that are creating both enforcement risk and consumer class action risk. And I want to turn it over to Jason, and who we work with in this area on some of the litigation to talk about some of these risks and enforcement actions.
Thanks, David. Now the important, we're getting to it even quicker than halfway. So for those of you guys looking for the CLE code, here it is. It's DS2921. And I didn't do a very proper job of introducing it, so I should have done a better job of that. David Mallen spends a lot of time involving disputes in front of the NAD, which we'll talk about a little bit later. Whereas I spend most of my time on, and both of us, I guess, do, on the consulting with clients on these risks and how to navigate the waters. And my role is also as a litigator here at Loeb and Loeb. If and hopefully never win, but if and when a lawsuit is brought, either for FTC enforcement or by a consumer in a class action sense. So with that little note, my interest obviously is watching what the regulators do, because you can tell when consumer class actions are going to start bubbling because they start paying attention to what regulators do. So this has been around, as David mentioned, a while. It's nothing really new, but because of, especially during COVID times, because of the growth and explosion really of e-commerce, I'm sure you've seen for those of you who live in Chicago or a place like it, you've seen all the the Amazon boxes and others piling up in the alleys, because people have become much more used to simply ordering online those things that they would normally have gone to a store for, even if it's down the street. And so the e-commerce is getting a lot more notice. 2010, they passed what was called the Restore Online Shoppers Confidence Act. And this was kind of the first shot, I think, that Congress took to regulate some of the online behaviors of advertisers, but really didn't focus so much on the kind of dark patterns we're talking about. It was more of the opt-in type things that we've been all dealing with and navigating for a while now. It wasn't until a couple of years ago that there was a bipartisan effort by Mark Warner out of Virginia and Deb Fisher out of Nebraska to kind of focus more on these deceptive practices. And they came up with a very clever name called the Deceptive Experiences to Online Users Reduction Act, or DTOR, which for those of you who were listening earlier to David, you will know is one of the types of tricks that they attempt. They've labeled a dark pattern as this kind of misdirection or obstruction type activity. It has not passed. Obviously, we'd be talking about that, but it still is alive in Congress, and there are still two sides, actually. Both the House and the Senate have variations on this act. Its definition is broader, and as David mentioned earlier, one of the biggest problems with dark patterns is that the definition continues to broaden. It's one of those things that's almost gotten not quite as bad as you know when you see it, but it definitely is broad enough to capture a lot of things that I think most companies would find to be just normal advertising. So here, it's any activity would be illegal that is to design, modify, or manipulate a user interface with the purpose or substantial effect of obscuring, subverting, or impairing user autonomy, decision-making, or choice to obtain consent or user data. And so, again, as David mentioned, there's a very gray area because obviously, generally speaking, all advertising is done to influence a consumer. That's why it's done. That's why we do it. And so the question is, when does it cross that line? Congress is not alone. State legislatures are passing similar type laws, following up on the ROSCA and DETOR type statutes. Colorado has a statute that actually has passed in its House and Senate and is now awaiting governor's signature. They define dark pattern similar to the one mentioned by David earlier. The means of using a user interface designed or manipulated with the substantial effect of subverting or impairing user autonomy, decision-making, or choice. You may see how that tracks the DETOR language. And it specifically holds that any agreement obtained through a use of a, quote, dark pattern does not constitute consent. So for those of you who, as a litigator, I deal a lot, especially with things like TCPA and those types of statutes, consent becomes a big issue. And if you have a argument that could be made by a consumer, for example, that a particular activity online may interrupt that flow of consent, obviously that's a big deal. So that's, it's not just the statute itself, but how it interplays with other statutes that require consent. Washington, likewise, is working on a statute. It's currently dead, but it does also reference the phrase dark pattern and uses a very similar definition like that found in the DETOR draft. Also, for those of you who watch California, which of course all of us do because they're always active out there, the California Attorney General has just recently approved a few months ago modifications to the supporting regulations of the CCPA, or the California Consumer Privacy Act of 2018. The modifications, again, specifically reference the phrase dark patterns, and they talk about options that advertisers and user interface companies that use user interfaces should consider, including a privacy option icon that you can click immediately once you enter a website, as recommended by the California legislature. So the CCPA includes mostly focused on opt-out, mostly focused on opt-outs. They define dark patterns as follows on the slide. Using an opt-out request process that requires more steps than the process to opt back into a sale. Using confusing language like double negatives. Requiring consumers to click through unnecessary reasoning before opting out. Requiring a consumer to provide any personal information before opting out. Or requiring a consumer to scroll through text before clicking on the do not sell. I'm going to give you a little bit of a horror story. So one of our clients has already received a letter from the district attorney. As some of you may know, often it's the district attorneys that are first to strike in California. And they received a letter, and I took it back to the client, and we're having a conversation. And as David mentioned, the immediate response from the general counsel is, of course, we would never do that. We, of course, then checked with the marketing department and found that perhaps maybe one of the efforts may fall within one of these 5 things we're talking about. Again, not intentional, nothing malicious about it, but there's sometimes the over imaginative efforts of the marketing group may get beyond what the statute. So it's important that we keep on top of these things. In addition to the legislatures, FTC attorney generals and consumer litigators have also been paying attention. In 2019, 22 attorney generals identified through a Better Business study that over the past 10 years, they've the offers of free trial offers. So the idea that you basically go into a purchase for free trial offer, and then it converts to a monthly or yearly subscription, for example, it cost consumers $1.3 billion in the last 10 years. In 2010, which obviously is a while ago, so the numbers have not been updated, at least that we could find, But by 2010, the Attorney General of New York had already reached 23 negative option settlements, similarly, that you just continue to be renewed until you say no. In more recent time, FTC has now brought 20 cases regarding inadequate disclosures in the past 3 years. One particularly notable FTC enforcement action is the In Re Age of Learning. And this will give you a good example of what at least the FTC considers to be a dark pattern. If you read this, you can see as you're trying to leave the website, it goes on to basically, in a way, I guess, maybe not shame, but it definitely gives you the hint that you're not doing enough for your child. So if you read it, it says, if you find that your child is not as engaged as an ABC as you'd like, we find that many children love, and they give you other areas that you should go through to purchase something. The way of this kind of obstruction of exiting a website is the kind of thing that the FTC is focusing heavily on lately, and they did in fact get an enforcement action against the in the Age of Learning. A similar settlement was in 2015 with LinkedIn. This was a class action. It involved what would now fall into the definition of dark pattern in most of these statutes we've seen. It had an allegation that consumers were tricked into believing that a connection email was driven by a connection. In other words, you'd get an email in your inbox that said, Jason Steele has recommended you for LinkedIn. Digging deeper through the LinkedIn, they realized that perhaps there was some gaps in that connectivity. And that case did settle publicly for $13 million as a consumer class action. In addition, there's been FTC actions in the past few years. In 2017, there was a television manufacturer regarding its smart software installed that would track consumer habits. That settled for $2.2 million. And last year, the FTC announced, and this is the auto renewal we were talking about, this is the ABC Learning case, ABC Mouse case. They settled for $10 million in that case. And with that, I'll turn it back over to David to talk about some of the recent NAD actions.
Thanks so much, Jason. And as Jason noted, we do a lot of counseling in this space. And one of the things that we get involved in is sort of understanding the interplay between regulation and self-regulation. So at this Federal Trade Commission workshop last month, there were several panel discussions. I mentioned the academic research, as well as the consumer advocates, but there was also a role for self-regulation, like CARU for the Children's Advertising Review Unit, which is concerned with children's online privacy, because again, this is an issue that is certainly relevant in terms of advertising and e-commerce, and also privacy. And Jason gave the examples of the privacy statutes that are expanding to specifically reference dark patterns when they're talking about opt-outs, pre-checked boxes, misdirection, and those kinds of things. But the other self-regulatory entity that's very much involved in policing the frontiers of this space is the National Advertising Division, the NAD. Those of you that are familiar with the NAD may know that what they are primarily involved with are competitor disputes. Most of what they look at are advertising cases that are brought by competitors who see that this process as a cost-effective way of resolving disputes rather than going to court and suing under typically the Lanham Act in federal court. That's really the bread and butter of what NAD does, and it's issues of claim substantiation, adequacies of disclosure. But NAD sees itself as a self-policing entity that will apply consumer protection law and tries to harmonize what it does with the standards and guidelines and guidance of the Federal Trade Commission. So they'll apply, for example, the guidance towards making disclosures online. They will apply the endorsement and testimonial guidelines of the FTC. And most recently, the National Advertising Division has been very involved in this area of dark patterns. I mentioned that most of the cases before the NAD are these competitor disputes, but probably about 25% of NAD cases, maybe a little more, come from their own monitoring efforts. It's where NAD actually acts as something of a self-regulatory enforcer, and they will challenge companies where they have concerns about their online practices. They are getting increasingly involved and increasingly aggressive in this space in fulfillment of their mission being to uphold high standards of truth and accuracy in advertising. So one recent example where the NAD was involved, on their own initiative, they pursued a monitoring case against an online retailer called Fabletics, who makes fitness wear. And what they did is they offered discount prices with the VIP membership. To get the discount prices, you had to pay a monthly subscription fee. And so on the interface, they would advertise these fairly deep discounts. And then when you act on the offer, the interface took the consumers through a buy flow. If we can go to the next slide, they were given a quiz and asked to update information about what are your size, what size shirt do you wear, what styles do you like, what are your fitness goals. There were all of these things that a consumer was invited to do before it was revealed to them that a subscription was required to purchase the product at the advertised price. So that is an example in the eyes of the NAD of a dark pattern. Now, the way that the NAD process works, they don't come after you for money the way that the Federal Trade Commission does. That's the good news. The NAD makes recommendations that advertisers change their advertising to adhere to principles of truth and accuracy. And so in this case, they recommended that the company update their disclosures, to bring it up front, to disclose that a subscription was required when they make the offer in the first instance. Again, this isn't inconsistent with consumer protection laws that are already there, but it has become a priority for the NAD in terms of their own monitoring efforts. And there's two reasons why that's important. Number one is there is an element of publicity and press when the NAD gets involved. So most recently, the NAD opened a case against a company for loans that advertised that certain loans were available. But in particular, the ad was no registration is required, no login is required to obtain a small loan. And in the eyes of the NAD, this suggested certain things about collection of data. They thought that this implies that they're going to protect your privacy. If you don't have to register, they don't need your data, they don't have to run credit. And of course, that's not true because this is in fact a loan. But what's interesting about this case is the decision made by the company not to participate in the NAD practice or NAD process. It's a voluntary process that self-regulation is involved with. However, when a company decides either we're not going to participate or we're not going to follow a recommendation, the NAD then refers that case to the Federal Trade Commission. And in doing so, they also issue a press release. And that can have certain important consequences. One of those consequences is consumer class action lawyers who read these press releases. It may not create vulnerability in terms of the legal aspects of a case, but it creates exposure. It provides plaintiffs' counsel with a larger pond within which to fish. And so they're definitely watching those cases. The other aspect of NAD's involvement is this. NAD is a process where companies can challenge what competitors are doing before them. So NAD sees it as their role to kind of establish guidelines, establish standards. So when you're telling your business people they can't do something because it's going to run afoul of dark patterns or some consumer protection law, and your competitors are, NAD is saying you can challenge those cases before the NAD, and we will issue recommendations and try to raise the standard so that these practices don't become a race to the bottom, inviting scrutiny from regulators, enforcers, and consumer class actions. And to talk more about consumer class action risk, I'll turn it back to you, Jason.
Thanks, David. I mentioned earlier that consumer class action lawyers watch the regulatory. David just reinforced that. I mean, I think that in both of our experiences, you can almost always draw a line back to a publication by a local AG or by the federal government or someone who's watching a statute develop in Congress is almost always the precursor to what becomes pretty major litigation in the consumer fraud space. And I reference it here that for those of you, hopefully, who have not had a chance to deal with states' consumer fraud statutes, Most of them are referred to as the Little FTC Act, because what they essentially do is allow a private right of action under state legislatures for what would typically be an FTC type enforcement action by the federal government. And so there's a variety of laws across the states that have a variety of statutes that support what constitutes fraud, and they evolve yearly, literally almost on an annual basis. You know, Illinois, I think, adds a new sub-statute for its consumer fraud statute on an annual basis. And so monitoring it is important, because it's my expectation that to the extent that dark patterns don't become their own standalone statute in a state, it very well will become codified somewhere, most likely underneath one of the little FTC acts of a particular state. There's been 2 class actions recently against Noom in New York under their statute, which is the General Business Law Section 349. Noom, for those of you who don't know, is a health and psychology science kind of a melding, where it basically works with the consumer in a way to learn about their choices and help them make better decisions on a health and wellness standpoint. So there's a lot of internal monitoring of what an individual is doing that helps them then live a healthier life. And what this particular class action focused on was the negative option specifically, and it spends about 50 pages going through the history of negative options, the types of enforcement actions that have been brought. So if anyone's looking for more education on the history of dark patterns, this is a good class action. The complaint itself is a pretty good recitation of that. But what a negative option is, we talked about it before, is that automatic renewal type concept that many states have also put into statutes separate from their own consumer fraud statutes. But then it goes on a little bit further, and it also focuses on that countdown, or that urgency that David mentioned earlier as an example. So when you get to the end of your sign-on for Noom, it gives you this countdown clock that they allege to be a quote-unquote fake countdown clock that basically gives you a sense that if you don't make a decision within a certain period of time, the offer that you've been given or the opportunity that you've been given will go away. And obviously, for those of you who are old enough like me, I remember sitting and watching some TV shows, and then those commercials would pop on for, a rock CD or whatever it would be. And it was like, act now, and you can also get, these products. It would seem that type of advertising, at least in the current belief of some statutes, would fall into a quote unquote dark pattern if it wasn't accurate, obviously. That if there was some urgency or limited supply of a particular product. And so again, I want to emphasize that I think we're on the precipice of what I believe to be some pretty active consumer class actions. I attended a conference, I guess it's been about a month now, where both plaintiffs and defense bar spoke about class actions and kind of trends. And number 2 on the plaintiff side was this consumer fraud user interface concept. They actually didn't use the phrase dark patterns, but they referred a lot to the types of things that David mentioned earlier, the confirm shaming and the obstruction and the multiple click-throughs. So I think it's just a matter of time before they get more and more savvy on what what Congress is already starting to do and other state legislatures are starting to do. So at this point, we wanted to kind of walk through some examples of things you might see, or frankly, your company's already started using, and just to kind of walk through what FTC has determined not to be appropriate. So here's an example of a practical example of a sign up to receive 6 months of data protection and credit history monitoring for just $1. And then if you look at the options, one is a very positive, yes, it's in red bold, and it says, yes, I want to protect my identity. And then the other one says, no, I don't want to protect my identity. So in a way, it's confirm shaming you into saying, no, I'd rather the whole world see all of my information. I mean, and again, almost in a way to make you feel like you're making the less than intelligent choice of for $1, why wouldn't you sign up for such a product?
And on that one, Jason, I think to the extent that there's going to be enforcement risk, it's also going to have a lot to do with what those terms and fees are, right? Because it says additional terms and fees may apply, learn more. Okay, that's sort of on the line right there, right? I mean, but if those fees are extensive and I'm being pushed in a certain direction, that's where things are going to come together and create risk. And I think with a lot of these, it's going to be the combination of elements. And we're going to see increasing amounts of research and surveys done on the way consumers react. And yeah, I think plaintiffs' counsel are going to be very involved in sort of conducting the kinds of research and analysis of online behavior to bolster their cases.
Yeah, I would agree. In fact, I had a conversation a couple of days ago, and one of the things that came up was how much plaintiffs' lawyers are becoming much more sophisticated when it comes to the scientific side of things, not just with this, but just generally. If you look at a lot of the food cases recently, I mean, they spend a lot of time and money getting, maybe not a very reputable, but getting a food scientist of some sort to do a survey, to do a study, to evaluate products, and those usually become front and center in their complaints. And so I agree with David. I think you'll see them using a lot of these studies and surveys that go through behavior. And it's worth pointing out, I mean, there is a website, and it's called Dark Patterns, and I can't remember if it's org or com, but you can look it up afterwards. It is a very detailed website that basically encourages consumers to file complaints, to assess of what things they've seen online, and to report them through this online reporting service. So it's active, and I think that, like we said, I think they'll become much more and more sophisticated. Here's another example, similar. In this case, a couple of things. We've got the agree and disagree. So again, it's giving you what would appear to be a unintelligent option, but I don't want this, and you're basically having to affirmatively state that you disagree with protecting your own data. And then you got another little sign me up thing down here. So a lot of companies will automatically check boxes. That's one thing the FTC has been focusing on, whether or not it's a need to check box or if it's a box that's already checked. But then you also see below it that it's got a kind of, again, another stab at the consumer. Don't uncheck this box if you love lawyers. And so it's, it gives you this option of, well, I don't know, I don't really like lawyers, so I don't want to uncheck the box. So those kinds of decision making, and it's amazing the psychology that goes into some of these decisions. And I'm sure most of you on the webinar aren't, it's not unfamiliar to you, the amount of psychology that goes into how companies advertise. But these types of things have a pretty serious impact on whether or not a consumer will feel guilty about checking or unchecking a box before making a decision. And the FTC is paying attention. I don't know, David, if you had something else to add on this one.
Yeah, there's a lot of, you make the very good point that there's a lot of elements going on. And here the colors of the boxes are the same color, but on the other hand, you have this confusion, agree and disagree. Those aren't really the right words for something like that. And one of the really interesting takeaways from the FTC workshop was that these very subtle forms of what they call dark patterns tend to be the most insidious ones because they're the most effective. The ones that are really over the top, the ones that confirm shame in a ridiculous way, buy this because you don't want buy this travel insurance because if you die in a fiery plane crash, your family will be penniless or something like that. Those don't work, obviously. That's a negative consumer experience. It's the subtle ones that, you may think of as, oh, well, that's not really deceptive, but those are the ones that they're going to be the most interested in. So a lot of these appear fairly innocuous, but put together enough elements and they could get close to the line, at least in the eyes of some of the regulators.
So similarly, I think we're kind of going through these, but I think it's important because I think, I'll be honest with you, when I first learned of the phrase dark patterns was not that long ago. I won't admit it because I don't want to seem like I wasn't paying attention, but it's been recent history. And it's amazing when you go down the rabbit hole of the types of cases and the types of things that are out there, how many, as David mentioned, how many nuances there are to what the FTC is watching. And like David mentioned, their workshop was very informative on kind of the different tendrils that are kind of part of this dark pattern, at least according to the FTC. And so Here's another one. Couple things on this one, right? You've got this additional line in here that basically is giving you an urgency, right? And I've been part of a website where sometimes that's even flashing at you, right? Like it's almost a warning, like it's already happened. Your information's already been stolen, or it's compromised. Act now. And additionally, you've got that the limited opportunity, right? Act fast. Only a few are left. Now, again, as David mentioned, if these things are true, then of course you can say them. But where it becomes tricky is where you're using these to basically convince a consumer when you don't have the facts or the information to support the claims that you're making. Likewise, same color buttons, which is something that is better, but then underneath it, under the agree, it tells you this is the right choice for you to make, right? It has the parenthetical recommended. We don't know who recommended it. We don't know why it's recommended, but the website's telling you that this is the right decision to make. So, David, anything else?
I guess the other thing is, well, what's being offered here is some kind of service that's supposed to protect your identity. What the FTC likes to do is they like to find false claims also. So if that claim is also exaggerated on top of these practices, they can get a couple of these consumer protection issues to dovetail into a nice, sweet complaint or CID or letter. They look for those kinds of cases.
Cancellation. So we've talked a lot about the signing up. So now we're going to the other side of things. This is, again, an example of a situation where it's making a consumer feel bad about their decision to leave a particular program. If you read it, it says, if you turn off your service with us, it assumes, we won't be able to help you protect your personal information. Are you sure you want to decline identity theft protection? Question mark, exclamation point. And so, again, you've got the guiltiness of the question, but then if you look at the phrasing of the answers, it's interesting because it really does mentally mess with you a little bit. It says, are you sure you want to decline? And it's no, cancel, which is backwards. And then the second one says, yes, I don't want to protect. So you've got the positive and negative juxtaposed in a way which would be very confusing for a consumer to see and make a decision on. And I think, as David mentioned, one of the things that, these false claims is obviously a huge thing for the FTC, and they monitor it all the time. And as David mentioned, now the NAD, not now, but the NAD also can take on a kind of a regulatory board perspective and actually monitor. They don't need it to be affirmatively brought by a competitor. And so if you are being watched, and like I said, the Dark Patterns website identifies companies, it puts people on their quote unquote list. And so if you're being watched, you can assume that there's someone else out there, a consumer, a plaintiff's class action lawyer watching you while you're doing these types of things. And I don't know, David, anything else on this one?
I think this is I think the FTC would find this one fairly egregious. Our colleague Caroline Hudson and I had a conversation, and we talked with Mary Engel, who used to be the head of advertising practices at the FTC, and she was concerned about this one because of that word cancel. It's used in a misleading way here. You think you're canceling the identity theft protection because that's prominent, but what cancel means here really is cancel the function. You look at the other box, it says, no, I don't want to protect my identity. That's the box you need to click to actually get out of the service. And I think that's really confusing. And it wouldn't be hard for the Federal Trade Commission to reach the same conclusion.
So similarly, this is the same kind of idea, but now we've added a couple more things. One that we've seen before and talked about, which is the continue to decline and that's recommended. But what you're continuing on here is something you probably didn't pick up on, because there's a second line below here that's in lighter font and smaller font. And it says, before you go, you may be interested to know that we offer something special, 68% off of your subscription price. So in fact, what you most likely are continuing here is to take you to the 68% more off of your subscription. So it would likely, rather than allowing you to leave, it's going to take you to another screen and give you another option getting a reduction in your annual or monthly fee, whatever it might be. And so the button, again, like to David's point on the last one, the button that you like to push most likely is no thanks, I'll wait. Although again, I think given what the FTC is looking at, even that might be seen as too many steps away, requiring a consumer in the California regulations we talked about, too many steps. If a consumer wants to go, you have to let them go. You can't continue to make them go through hurdles before they can get out of your website. And again, I think there's also some vagueness on the other options. I mean, who knows what those other options may be, David?
Yeah, and you have the added element of a scare tactic here. You know, you're in trouble if you don't do it. You're really at risk if you don't do it. I think with the canceling of a subscription, it can be tough though in terms of where to draw the line. It's not deceptive to simply say, "Are you sure you want to cancel?" If you were to sort of make one offer, you know, if you stay, we'll give you this. I don't think you would run afoul if that was all that was going on. But, you know, you throw 4 or 5 at them or make it hard to navigate the website and actually find that cancellation button, that's where it's going to be a problem. As you pointed out in that FTC example for the learning, age of learning. So, but this is an area, because this is one where we know if it's deceptive, consumers are paying, right? Like there's real harm if in fact there's deception. And obviously the FTC will probably focus on cases where that's going to be an easy thing to prove.
So, you know, I'll turn it over to David. I know I've been doing so much talking, so I'll start with you, David. I'll let you walk through these, and obviously I can jump in at the end or throughout. But you know, obviously the whole part of having this webinar and for us to bring us together here is to, one, bring it to your attention. You know, I'm sure a lot of you are already aware of some of these things, but like I mentioned, I hadn't been until it became a consumer class issue about a year ago. And so when that happens, obviously it's front page news, at least in my world. But really what we're here for is to help manage, and that's our job, right? I always tell my clients, I'd rather be your fire marshal than your fireman. And so our job here is to help you guys all understand these risks, and then what we can do to manage them. So David, I don't know if you want to walk through some of these.
Yeah, I mean, just in terms of it starts with a certain awareness, a certain sensitivity to this issue and to these practices, and to the fact that routine practices in e-commerce can, if not done in a very thoughtful way, you know, get really close to this line or even trespass upon it. So creating internal awareness within a company, having workshops and education with the brands, with the folks running the social media campaigns, particularly where you have things like subscriptions, you know, things like a buy flow where there's additional fees, and of course, in terms of privacy and anything involving an opt-in, opt-out kind of ecosystem, paying attention to these issues is going to be really important. Identifying key customer flows, certainly in e-commerce. I mean, legal should be involved in the entire process, of course, from start to finish. Doesn't always work out so easily, but navigating these things through the eyes of a consumer is going to be a really important one. But also not just the you know, a laptop. Make sure you're doing it on the small screen as well. I mean, these are in large part behavioral and communications issues, and so being in tune with those is going to be really important in terms of advising your clients and your marketers where they might be moving into a gray area or a risky territory. So improving the conversation within, having workshops, taking a holistic view at the goals of what you're trying to do. When you have the conversations with your marketing people and you ask them why you need that box there, or what kinds of, why is the box on the bottom right instead of the center left, understanding that those decisions have consequences, and making sure that you're having these conversations internally. If it crosses a line, or you're not sure, or you need some outside perspective, it's going to be important to get that, keeping track of the kinds of issues that are in the crosshairs of the regulators, the enforcers, and the consumer class action lawyers. Monitoring enforcement activity is going to be really important going forward. We mentioned several times this FTC workshop, and a question that I get a lot is, okay, so the FTC had this big seminar that they pumped it out there through the media. There've been a few articles. The scary term dark patterns is now floating around. What's next? What does the FTC do next? And what FTC does next is they review comments that have been submitted, and they make a decision internally whether this is something that necessitates additional rulemaking, which is an unusual step. Most things don't from the Federal Trade Commission, because all of these practices probably are within the jurisdiction and the enforcement powers of Section 5 of the FTC Act. But sometimes what happens is the FTC issues a guidance document, as they did for something like the Green Guides or .com disclosures or endorsements and testimonials. And these guidance documents actually can be helpful. Sometimes they provide good examples that will help business, navigate and understand where the lines are drawn and when they're coloring outside the lines and when they're getting close to the lines. However, whatever the FTC does, it almost always is accompanied by increased enforcement. And there's a real appetite for it in this political environment and with this Federal Trade Commission. And they don't come out of nowhere, the FTC. They don't bring a case out of the clear blue sky. They've been firing a lot of warning shots across the bow. And I think that when they come out with something, whether it's a guidance document or a staff report, we can expect it to be accompanied by a fresh and new round of enforcement activity, specifically focusing on dark patterns. The final point, and Jason, I'll let you get the last word to wrap any of this up, and then hopefully we'll have a little bit of time for questions. Pay attention to competitors too, not just in terms of benchmarking. I mean, the last thing you want to be is the lowest hanging fruit out there in terms of being a target for the regulators and the enforcers, but also think about the kinds of things that you can do to encourage your competitors to raise the bar and make use of self-regulatory guidance so that you're not pressured to be in a risky place in terms of your own practices.
Yeah, and that to me, that's one of the most important things. It's in the last few years, as I've been spending more time on the consulting and less on the litigation side, I find it incredibly instructive, that when I have a client in a particular market, to then go out and look and see what 4 other companies are doing on their websites. One, because it shows you again what the trends are, and maybe they're trends we should adapt or adopt on our own if they're appropriate. But it also gives you a sense of, as David mentioned, you don't want to be the outlier. You don't want to be the one who's using a tactic or something that's going to catch the eye of a consumer class action lawyer or a regulator. So again, it's not necessarily keeping up with the Joneses, but not being outside the purview of what the Joneses are doing. So, and I think one thing that I found really helpful with clients is what I like to call the stoplight methodology, and it's something we do a lot for our clients, which is they come in these key customer flows, and they basically will send us a PowerPoint presentation or sometimes even a module where it walks through, as David mentioned, kind of then this, like walks us through a consumer's experience. And they'll just simply ask us, red light, yellow light, green light, like, is this okay? Is it risky? And if it is risky, what are those risks? And I think, we're getting enough data now from both some of these studies we talked about, but also from some of the enforcement actions we're seeing, where we can do a pretty good job kind of navigating the risks and the waters on these types of these things, because obviously, again, the scrutiny will only get higher and the risk only get greater that someone's paying attention to how you're navigating. So, I think that does a pretty good job of getting us to the end. We've got about 5 minutes left. Nothing other than unadulterated praise so far on the questions and answers. So, we'll accept all of that. But if anyone has any questions, we have 5 minutes. We're happy to answer a question or answer on anything about dark patterns, or if you want to know, how long David's been growing his beard, we're happy to talk about that too. Whatever you want to talk about. Otherwise, I think that'll bring us to a close. So Thank you guys very much. Like I said, I actually enjoyed learning more about these dark patterns, learning more about what's going on out there, and kind of tracking the FTC. And I hope that you guys got a lot out of this. So, David.
Thanks a lot, everyone. And if you think of any questions, or don't hesitate to reach out to Jason, to myself, to any of our colleagues. Thank you for your time. Thanks for joining us. And thanks for taking part in the connectivity webinar series from Loeb & Loeb.
Thanks, everyone.